So again, welcome to the continuation of the Philippine Bill of Rights. We will tackle the Section 3 to Section 22, or I'm not mistaken, if I'm not mistaken, the Philippine Bill of Rights under the Article 3 of the 1987 Philippine Constitution. So Section 3, what talks about the Section 3? Section 3 talks about the right to privacy of communications and correspondence, wherein the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety orders requires as prescribed by the law. So ano to, ma'am? Right to privacy of communication. For example, do you have your Facebook? Do you have your messengers? You have your contacts, your logs? May ka-call kayo, lahat yan, you have your own privacy. So, dito yan pumapasok. So, any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. So, for example, as ni-record nila, kunwari may kabit ka, ayan, ni-record nila yung call nyo, yan, without your permission or kahit wala namang, for example, for this officer, bawal po yun. Diba? Every person is entitled to privacy as to letters or any messages in written or electronic forms. So, lahat meron yan. Even in written letter, or sometimes, syempre, mabilis ang ating technology ngayon, in messenger, in social media, or even any platform that conveys a message. So, ano ba yung mga yan? Ano ba yung mga exemption? So, marriage is not a valid defense to disrespect privacy of communication and correspondence. So, for example, may asawa ka, tapos tinatago niya yung mga, for example, call logs niya with her boss or with his boss, wala kang magagawa dun. Meron pa rin siyang privacy of communication. So, hindi porket mag-asawa na kayo, kailangan ibigay niya lahat ng password sa'yo. Okay? And under the Anti-Wiretapping Law, RA 4200, intercepting telephone conversation without any authority or court order is invalid and therefore against the law. Kailan lang nagiging valid ito? Ano ba yung wiretapping law, ma'am? For example, sa telephone. Okay? For example, sa telephone. Wait lang, Angelica. For example, sa telephone, meron tayong crime. Ngayon, meron kasing transaction yung hostage taker, ganyan. Ma'am, bakit nila parang pinakikinggan yung usapan? Okay? Meron naman yon, magbibigay sila ng court order. When it comes to crime, in relation to crime, wiretapping is legal. Basta merong court order. Kailan siya nagiging illegal? Kapag wala namang court order, kung wala namang crime relation, and then mag-wiretapping ka, yung nakikinig ka sa usapan ng iba, bawal po yon. So, wait. Yes, Valdez, you raise your hand. Do you have any question?
Ma'am, napindot lang po. Sorry po.
Akala ko may tanong ka. Okay. Overhearing conversation using telephone extension is not covered by communication privacy rights. O, yung mga chismoso tsaka chismosa. Ma'am, kausap ko kasi yung jowa ko. Ngayon, yung kapitbahay ko, nung bumibili ako sa tindahan, accidentally dumaan siya. Ngayon, narinig niya yung usapan namin ng jowa ko. Tatanungin ko kayo, meron na bang nilabag yung kapitbahay niya? May nilabag?
Wala po.
Wala.
Wala
Kapag ganun lang, yung napakinggan lang, overhearing lang, yung hindi sinasadya, ganyan, wala siyang doon sa communication privacy. Wala siyang nilalabag na privacy rights doon. Unang-una, hindi niya ginusto na pakinggan yan. Unless, siya mismo, sinusundan ka niya, okay? At saka, siya mismo is, kung saan ka man pumunta, or habang nagko-call ka, tinitingnan na pinapakinggan ka niya, doon pumapasok yung communication privacy rights mo. Okay? Overhearing, yung napakinggan lang niya. Di ba nga sa jeep? Sino mga ganito sa jeep? May nag-aaway sa jeep, magjowa, napapakinggan nila yung call. Kasalanan mo ba yun kung narinig mo yung pinag-uusapan nila?
Hindi po.
Hindi, di ba? So, hindi kasama yun. Hindi nyo pwedeng isampahan ng kaso na, yung mga yan pinakinggan yung pinag-uusapan namin. Okay? Next. Upon written application for crimes against national interest, any peace officer is allowed to procure a written order from the court to record, intercept, or overhear private conversation. So, sabi ko nga sa inyo, when it comes to, in relation to a crime, okay, pwede tayong mag-wiretapping or pakinggan nila yan, yung mga conversation within the phone calls. Yan. Pwede yan. Basta merong court order. So, those in possession of recorded conversation may also be held liable in case of disclosure. For example, meron kang recorded conversation nito. Ngayon, biglang lumabas sa publiko. Ayan, magkakaroon ka ng kaso dyan. Lalo na kung, for example, binigay yan ng korte sa inyo na gagamitin mo lang yan for evidence. Tapos, kumalat. Yan. So, magkakaroon tayo ng disclosure. So, can you now, alam nyo na yung right to privacy of communication and correspondence niyan? So, yung mga may jowa dyan, hindi po required, ha? Hindi po, for example, kinukuha nila yung mga passwords ng mga jowa nyo, sabihin nyo, I have my right to privacy of communication. Okay? Nilalabag mo yung karapatang pangtao ko kapag pinipilit mong kuhanin ang password ko. Nagkakaintindihan tayo? Yes, Valdez.
Ma'am, paano po, for example, ako po yung kasama po ako dun sa case. For example po, yung drug pusher po, ay drug lord po siya, tas drug pusher po ako. Na-record ko po yung conversation namin or yung call po namin just in case po na magkahulian po. Pwede ko po ba yun gamitin as evidence po?
Yes,
Kahit
pwede. Yes, pwede naman. Kung gagamitin evidence as substantial evidence. Okay? Merong chance na hindi yan i-accept. Merong chance na i-accept yan. Kanino pa rin ano yan? Sa korte.
Thank you po, ma'am.
Okay? Kung kanwari, substantial evidence yung, for example, yung conversations nyo or yung recording na yan, substantial, accept pa rin po yan. Pwedeng gamitin. Okay? Next, Section 4. Ito. Section 4 states for the freedom of speech, freedom of expression, or freedom of the press, the right of the people peaceably to assemble and petition the government for redress or grievances. Ito na yung pumapasok yung pagwewelga. So, sabi dito sa Section 4, no law shall be passed, bridging, or walang pwedeng gawing batas na pinagbabawal ang pagwewelga. Ganyan. So, ibig sabihin, ma'am, yung mga nag-welga sa harap ng Malacanang, sa harap ng mga ganito, legal yan? Legal po yan. Okay? May mga written letter yan. Kaya nga meron ding, tawag dito, yung mga police operations natin, meron silang unit doon para sa mga civil disturbances or kahit sa mga crowds na 50 meters, ganito. Ito yung mga gagawin nilang parameters. Meron yan. Kasi legal po yung mga yan, yung mga nag-welga. Kasi nagkakaroon sila ng permit. Kasi nga, meron tayong freedom of speech, of expression, or the press, or right of the people to peaceably to assemble and petition government for redress of grievances. So, this right is expressed only as against the government. Ito yung mga nag-welga nga. For example, ang dami nag-welga ngayon. Kahit sinong lagay mong president or kahit sinong lagay mong, tawag ito, official, meron mag-welga. Pero bakit yung mga yun hindi sila hinuhuli, hindi sila kinukulong? Kailan lang sila hinuhuli at saka kinukulong? Kapag nanlaban sila or kapag nagtapon sila ng bomba, nagtapon sila ng anything that will destroy the public place or even yung mga taong or mga police officers natin na nagbabantay. So, content-neutral regulation is imposed as a limitation of this right. Content-neutral covers the following: the time, anong oras, the place, and the manner in exercising the freedom. So, for example, binigyan silang maghapon para magwelga kung saang lugar at saka yung paano sila magwelga. So, ganun po ang ating nagkakaroon ng bakit nagiging legal yung pagwelga nila. Okay? Kaya bakit hindi sila hinuli? That is the reason because we have the right for the freedom of speech or expression or even the right of the people to make those type of assemblies. Kaso nga lang, kailangan meron silang written letter. Kaya nga may mga, kung sino yung, for example, may nag-welga, merong head yan. Parang siya yung talking body or parang siya yung kinakausap ng mga officials. For example, dito lang kayo, beyond 50 meters, hindi sila pwedeng lumas ng beyond 50 meters. Kailan papasok ang pulis? Kapag mismong dun sa mismong line na yon, lumagpas yung mga nag-welga, doon. Kaya nagkakaroon ng riots between the police officers at saka yung mga nag-welga. Kasi nakita ng police na, lumabag na sila dun sa usapan. So, it is also subject to tests, that may result to curtailment of right and liability. So, we have the different tests, the clear and present danger rule, the dangerous tendency test, and the balancing of interest test. So let's start first with the clear and present danger rule. So the words are used in such a circumstances and are of such nature as to create a clear and present danger that they will bring out the substantial evils that a lawmaker has a right to prevent. For example, naglalabas na sila ng mga tawag dito, official papers na bawal ipubliko. Ayan, pwede nang mag-act upon yung mga lawyers or yung mga legislators natin noon. So the government has the right to be protected against the broadcast which incite listeners to overthrow it. Lalo na yung mga nag-i-incite to commit treason, incite to commit rebellion, mga ganyan, mga crimes against national security. So bawal yung mga yan. We also have the dangerous tendency test. It requires if the words uttered create a dangerous tendency which the state has the right to prevent, then such words are punishable. It is applied to detect whether an act causes evil for society. So when a substantive evil is identified, it is not unconstitutional for a government to interfere. So kapag nakita nila na yung mga pinagsasabi nilang words is, parang yung sinabi ko nga sa inyo ulit, yung na parang nag-i-incite sila to commit rebellion or treason or kudeta, ayan, nagaano na yan, binabawal na. Merong karapatan ng gobyerno na supilin sila. And then we also have the balancing of interest test. It is any judicial test naman to. In which the juries weighs the importance of multiple factors. It requires that a determination must first be made whether the necessary safeguarding of the public interest involved may be achieved by some other measure less restrictive or protected freedom. So, yung mga balancing of interest test, ito naman sa korte na. So, dun sa letter nila, titingnan nila if yung content talaga nila is okay naman. If hindi, babawalan nila. So ito, hindi na yung government mismo or yung mga legislators ang bumabawal sa kanila. Ang sa balancing of interest test, dito yung jurist na, pumapasok na yung sa korte. Whether nalalagbag ba yung karapatang pangtao nila or nalalabag naman ng masyado yung sa gobyerno. So, limitation on the freedom of expression. Siyempre, hindi naman po lahat. So, we have the overbroad regulation, the content-based regulation, and the content-neutral restriction. So, overbroad regulation, a regulation of speech, is unconstitutionally overbroad if it regulates a substantial amount of constitutionally protected expressions, which provides a regulation of speech can sweep into broadly and prohibited, protected, as well as non-protected speech. Ito na nga yung mga naglalabas sila ng unofficial documents na bawal i-publiko. Dumalabas sila dun sa content or yung mga pwede lang iwelga. Yan. Yung content-based regulation naman, ito yung mismong regulation of speech or expression that is based on the substance of the message. Substance, hindi nila tinitingnan dito kung paano na iwewelga yon or paano nila sasabihin yon, kung paanong way. Wala sila doon, wala sa medium. Ang gusto nilang kuhanin dito is ano nga ba yung nilalaman nung sasabihin nyo or nung pinaglalaban nyo. That is a content-based regulation. Regardless of on how, okay, on how you will portray it, on how you will give the message, ang base nila dito is yung laman ng message mo. Yung namang content-neutral restriction, a restriction on the manner. So, kung yung content-based nasa laman, ito namang content-neutral kung paano, kailan, at saan. Ito yung nauna, na sinasabi ko na may permit sila. O, ito, gantong oras. Ganto yung gagawin nilang pag-uwelga. Ayan, sa ganitong lugar. So, a restriction on the manner in which an expression can be communicated or conveyed. These restrictions apply to all communications regardless of the message or view being espoused. So, these are known the time, place, and manner restrictions. So, kayo ba, are you been involved or have you been involved in any kind of ganito, yung mga pag-uwelga?
Yes po, ma'am.
Okay. Sometimes, hindi lang siya yung natural na, tawag dito, hindi lang siya yung natural na nakikita natin na physically magwewelga sila. We have also the freedom of expressions in posting our rants. 'Di ba? Sometimes in FB, ganyan. Normal lang yan. At walang magagawa yung Pilipinas dyan kasi meron tayong karapatang magbigay ng sarili nating opinion. So, definition of terms. Another, freedom of peaceful assembly, sometimes used interchangeably with the freedom of association. So it is an individual right or ability of people to come together and collectively express, promote, pursue, and defend their collective of shared ideas. Ito yung, for example, sumali ka sa gantong grupo na nag-uwelga. Yan. So, the right to freedom of association is recognized as a human right, a political right, and a civil liberty. The terms freedom of assembly and freedom association may be used to distinguish between the freedom to assemble in public places and the freedom to join an association. Freedom of assembly is often used in context of right to protest, yan, while freedom of association is used in the context of the labor rights. So, tayo, for example, kayo, pag nag-graduate kayo, kami, may mga groups or associations kami na involved kami. So, legal yon kasi kasama yon sa labor rights mo na kapag ganito professions mo, kanare sa accountancy, meron sila tinatawag na JP, diba ganyan? Sa CRIM, meron tayo kampilan, pick-up, ano pa ba yung meron tayo dito sa Philippines? Yun lang, alam ko, ang active ngayon kampilan, pick-up, yung PSS, JCSP yata yun. Ayan. Sa CRIM yan. So, kapag kanwari graduate ka ng CRIM or ano yung profession mo, pwede kang sumali sa mga association. Karapatan mo yun. Okay. Yun naman sinasabi nilang right for or freedom for assembly. Okay. Freedom of assembly. Ito lang yung pansamantalang grupo mo na kanwari sasali ka sa mag-uwelga. Kasi ganito yung pinaglalaban mo. Ayan. So, that is a freedom of peaceful assembly. May karapatan kang sumali sa mga ganyan. Next is freedom of speech. What does it mean? Liberty to speak openly without fear of government restraint. So, it is closely linked to freedom of the press because this freedom includes both the right to speak and the right to be heard. Ang pangit lang kasi dito, minsan, sumusobra yung freedom of speech ng iba. So, sometimes kasi, yung mga uttered words nila, for example, yung president, parang, binagbibigay ka ng, for example, ipapapatay kita, that is a form of threat. 'Di ba? Threat na 'yun. Kasi pwede mo hindi na siya freedom of speech. Threat na ang labas nun. Kaya hindi mo masisisi yung iba na kung bakit sila nasasampahan ng kaso. Kasi yung form ng pagsasabi niya, pwede siyang maging threat. So kayo sa freedom of speech nyo, though right natin to, medyo medyo maging responsible kayo dun sa mga words na bibitawan nyo. Okay? Kasi kahit meron tayong ganito, meron pa ring limit. Next is freedom of the press. It protects the right to obtain and publish information or opinions without the government's censorship or fear of punishment. So, censorship occurs when the government examines publications and productions and prohibit the use of material it finds offensive. Ito yung mga freedom of the press. So, for example, kung ano yung binabalita nila. Hindi naman, tawag dito, hindi naman kailangan, for example, yung 24 oras, kailangan submit muna nila yung mga reports nila doon bago nila ipahayag sa publiko. Wala po tayong ganon. So, nagkaroon lang tayo ng, nalabag ito yung freedom of the press, alam ko, nung panahon yata ni Marcos. Okay? Dito, wherein nakokontrol yung sa TV, yung mga press, kailangan kasi dumaan muna sa kanya yung lahat ng sasabihin nila bago ipalabas sa publiko. Doon lang ako alam ko na merong parang na-violate yung freedom of the press natin. Pero as of now, hindi naman nila tinitingnan ngayon yan. Diba? Kasi hindi naman kailangan meron lang silang regulations na bawal ipalabas, kaya nga meron tayong MTRCB. Diba? Yun lang. Pero linilimit lang nila, inaalis nila yung mga more on violence, more on sexual, okay? Yung mga, it would cause a public danger. Inaalis lang nila yon. Pero the rest, okay lang naman. So, both the freedom of speech and freedom of press are commonly called freedom of expression. So, we have two ways of freedom of expression, sometimes in speech or sometimes in press. Are we clear now with the section 4? Maliwanag sa inyo ang section 4?
Yes po, ma'am.
Okay, section 5. Ito naman, freedom of religion. Hindi ko na to masyadong, tawag dito, i-elaborate pa. So, we have our right to choose our own religion. So, kung gusto mong mag-Muslim, mag-INC, ano ba yon? JIL, born again, Catholic, lahat yan. Okay, kaya nga, alam ko meron nga separation of the government and the church, di ba? So, ganun rin. So, we have the freedom of religion. Walang sinasabing na religious test, di ba? No religious test shall be required for the exercise of civil or political rights. So, you have the right to believe and right to act on one's belief. So, for example, yun ang sinusundan nyo sa church nyo, walang karapatan ang gobyerno dyan. Okay? And let's go now with the section 6. The liberty of abode o yung pag-travel nyo. Liberty of abode and travel. Movement. Okay? The liberty of abode and changing the same within the limits prescribed the law shall not be impaired except upon lawful order of the court. So, pwede ka namang umalis kahit or pumunta kahit saan unless merong nagre-restrict sa'yo na galing sa korte. Or sometimes, because of our national safety, ganyan, katulad ngayon ng ating pandemic, so nagkakaroon ng limit tuloy ang ating liberty of abode and travel. So, neither shall the right to travel be impaired except, yan, in the interest of national security, public safety, or public health as may be provided by the law. So, hindi nalalabag yung karapatang pangtao natin. For example, nagkaroon ng lockdown or for example, nagkaroon ng mga checkpoints at hindi kayo pinadaan. Kasi, pumapasok dito yung national security, public safety, and the public health. Siguro kung walang pandemic, ayan, dun ka magreklamo at hindi ka pinapalis ng probinsya nyo. Unless, may kaso ka. Ayan. So, this right is not absolute. Kasi nga, sabi ko nga sa inyo, pwede yan maalis dahil lang sa mga instances. Okay? Sometimes, lawful order of the court, or sometimes yung ulit lang, national security, public safety, or public health. Okay lang? Bibilisan ko na yung mga rights na alam naman nating mas madali lang, ha? Ito, the right to return to one's country is not among the rights specifically guaranteed under the Bill of Rights, though it may be considered as a generally accepted principle of the international law, which is part of the law of the land. However, it is distinct and separate from the right to travel and enjoys a different protections under the International Covenant of Civil and Political Rights. Itong right to return to one's country, hindi po siya kamukha nitong tawag nito, right, liberty of abode and travel. So, sometimes kasi may restrictions in this one, dun sa returns to one's country. Saan papasok yan? Papasok na yan dito sa International Covenant of Civil and Political Rights. Section 7, ito, freedom to information or your right to have the information. Nakakita ba kayo ng mga bulletin? For example, dyan sa Sindalan. Di ba may bulletin dyan dun sa mismong harap ng school? Tama ba ako?
Opo, ma'am.
So, that is a freedom to information kasi meron tayong karapatan na malaman. For example, yung budget ng pagpapagao. Kayo, may ginagawang daan. Na-experience na ba kapag may ginagawang daan, merong tarpaulin na nakalagay na DSWD project, kung kanino project yan, sinong gumagawa, kung hanggang kailan nila gagawin, magkano yung budget, minsan mag-goal kayo 80 million, ganyan. Nakita nyo ba yung mga yon? So, that is your right to information. So, the right of the people to information on matters public concern shall be recognized. So, access to official records and documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development shall be afforded to the citizens subject to such limitation as may be provided by the law. So, meron kasi tayong mga tinatawag na documents wherein public talaga sila. Or once na ang document is na-notarize, alam mo yung public notary? For example, meron kang private document, pinanotaryo mo yan, makikonsider as notarized yan or public document. Pag sinabi natin public document, it only means na lahat ng tao may karapatang malaman yan. So, freedom to information refers to the right of the people to information on matters of public concern. It is the right of every citizen to access the official records. So, it includes the public rights to know the public officials and employees, assets, liabilities, net worth, and financial and business interests. That is why, yung mga nagsasabit sila ng mga salin. Ayan. So, syempre, para lang malaman natin if totoo ba nasa kanila yon or kung may nakukurakot. So, karapatan nating malaman yan. So, the rule on access to information about the Supreme Court guarantees one's privilege to either obtain a copy, receive the information, or gain insight to all informations and records or portions of those records in the official custody, possession, and control of offices in the Supreme Court. So, like all other rights, this is the right to know, or it is not an absolute right. For example, kinukuha mo yung mga list of personnel sa list of persons na nakakulong. So, sometimes hindi nila bibigay yan kasi confidentiality. Hindi naman lahat ng gobyerno maibibigay nila yung mga documents na hinihingi mo, lalo na kung confidential ang records. So, excluded are those non-disclosable information. So, katulad ng sinasabi ko na hinihingi mong list, mangyayari sa inyo yan, alam nyo ba, yung mga paghihingi nyo ng mga information within the government agency kapag magtitesis na kayo. So, sometimes, hindi nyo masisisi yung mga different agencies na tinatanong nyo within your thesis na magbigay ng information. Kasi, minsan kasi, yung hinihingi nating information is non-disclosable information or bawal ipamigay. It means, meron siyang confidentiality. So, it is protected by laws, rules of resolution of the Supreme Court, and bank. Yan. So, for instance, access to information will be denied if the request is made by one whose identity is fictitious, not legitimate. Mararanasan nyo yan kapag nagthesis kayo. Prompted by sheer or idle curiosity. Made with plainly discernible improper motive. Made for commercial purposes. It is contrary to laws, morals, goods, or customs. So, sometimes, yung nire-request, kunwari, ma'am, public information naman yung hinihingi ko sa kanila. Pero, bakit po hindi nila binigay sa akin? Kasi sometimes, ito yung mga grounds, no, kung bakit hindi nila binibigay sa inyo yung information kahit na public siya. Ayan. Kaya kapag gagawa kayo ng mga letters within the agency, kung magre-request kayo, pinapapirma nyo muna sa amin yan para malaman if tama ba yung content nyo, if ipagbibigyan ba kayo dun sa content na hinihingi nyo. So, exception to the right to public information. Information covered by executive privilege. Privileged information relating to national security. Ayan, hindi bibigay sa inyo yan. Defense or international relations. Information concerning law enforcement and protection of public and personal safety. Information deemed confidential for the protection and privacy of persons such as minor victims of crime or the accused. Ayan. Lahat ng mga yan, confidential yan. Bawal pong ibigay sa inyo. Ano pa? Ayan, ulit-ulit lang tayo. Prejudicial premature disclosure or even yung sa inofficial capacity deemed as confidential. Yan. Records or proceedings or informations, law or relevant rules and regulations, matters considered as confidential. Basta confidential. Kaya nga sa atin, sa security, meron ba kayong subject na security today?
Yes, ma'am.
Ayan. Pag-aaralan din yung mga types of documents wherein merong confidential, top secret, secret, restricted. Yan. So, doon yung malalaman yung mga types ng documents na pwede nyong hiramin. Next, Section 8, Freedom of Association. So, ito naman, sabi ko nga sa inyo, ano dapat yung hindi nyo pagkabaliktad dito? Yung kanidiscuss ko lang kanina. Section 8, Freedom of Association. Ano nga yung isa? Freedom to
Peaceful assembly po, ma'am.
peaceful assembly. Magkaiba yon ha. Kapag peaceful assembly, ito lang yung ano yun?
Right to protest po.
Ayan, right to protest. Kapag freedom of association, ito yung mga sinasabi ko sa inyo, nakagraduate nyo, sasali kayo ng pick-up, sasayawan kayo ng kampilan. Ito yung sa mga labor rights nyo. The right of the people, including those employed in the public and private sectors to form unions, associations, or societies for the purposes not contrary to law shall not be abridged. So, okay lang yan. Iba yung right for to freedom peaceful assembly, iba yon, at saka yung freedom of association. Sa association, this is parang groups na talaga, wherein meron kayong association or organization. Okay? Magkaiba yan. So, yung sa kampilan, alam ko dito, association lang siya ng Parang lalo niyang pinapalawak yung mga graduate ng CRIM na magkaroon ng seminars about cybercrime, about terrorism. So, maganda yung association na yun kasi lalong nadadagdagan yung information natin. So, kapag nag-graduate na kayo, you are free to join that association. So, there are some situations where public authority can restrict the freedom of assembly and association. So, this is only the case where the authority can show that its action is lawful, necessary, and proportionate in order to protect the national security, disorder or crime, health or morals, and right and freedoms of other people. So, action is proportionate when it's appropriate and no more than necessary to address the issue concerned. So, nagkakaroon lang na bawal yung gantong association kapag naman yung association nyo is, for example, to commit a crime or to commit a terrorism, bawal yon. Kasi hindi na, yung association nyo, hindi na for common good, for crimes na siya. Baka ang ginagawa nyo organized crime na, hindi na yung mga association just because of our labor rights. Ito naman, Section 9. Section 9, it is just simply known as right to just compensation. Padadaliin ko na lang to. Just compensation refers to compensation individuals receive when their property gets seized by the government for public use or purposes. Example na nga lang nito, road widening. So, kinuha nila yung, for example, karapatan mo naman yon. Talagang binili mo yon, yung lupang yon, kasama yung sa binili mo. Kaso pala, pag-aari ng, or gagamitin ng gobyerno yung daan na yon. So, hindi pwedeng kuhanin yan ng government nang hindi ka binabayaran ng tama or magtataken siya ng for granted. O, kasi kami yung gobyerno, so kailangan ibigay mo na lang yung daan na yan. So, kahit sabihin mong ikaw na ang pinakamayaman, kailangan, tama ang pagkabayad sa'yo. Walang private property na gagamitin for public use without just compensation. Sabi nga natin, it is the fair market value of parcel or property that must be paid to the property owner who has or had his or her property taken by the government. Any property, private property na taken by the government shall have the just compensation or yung tamang pagkabayad. Hindi pwedeng sabihin ng gobyerno na, ay hindi, total, mabait ka namang citizen, bigay mo na yung kalahati nito. Kung ito yung presyo mo, kailangan bayaran niya ng gobyerno na ganito ang presyo mo. So, eminent domain. So, meron kasi tayong power to eminent domain, di ba? May police power and then power eminent domain. Refers to the power of state and federal governments to take private property for public use or purposes. For example nga, yung daan nyo or yung bahay nyo na sa daan. So, meron kasing power yung state natin or yung government na eminent domain. But it doesn't mean na porket meron silang power of eminent domain, kukuhanin lang nila yung mga private property kahit walang bayad. Okay? So, kapag, for example, if the amount offered by the governmental agency taking the property is not considered sufficient, the property owner may demand a trial to determine a just compensation. For example, pinapabayad mo dapat yun 100,000. Ngayon, ang binayad lang sa'yo ng gobyerno 10,000. Pwede mong erase yan. Yes, Valdez.
Ma'am, paano po yung mga nag-squatter? I-relocate po ba sila or papaalisin na lang po basta-basta?
From the word itself, squatter na, wala naman kasi silang rights doon. Ibig sabihin, hindi talaga nila lupa yun. So, papaalisin lang nila yan. So, sometimes, kung mabait ang gobyerno natin or kung sino mang nakakasakop sa kanila, kailangan i-relocate sila doon sa mga NHA natin, sa mga National Housing Authority. Pero from the word squatter na, talagang wala silang karapatan sa lupa na yun. Bigla na lang silang tumira doon. Okay? Pero kaya may karapatan yung gobyerno na, sige, paalisin ka namin dyan, kahit hindi ka nila bigyan ng bahay. Yes, Jonel Pamintuan.
Ma'am, possible po, di ba po, if ever napapaalisin po sila, bibigyan naman po silang date, ganun po, di ba?
Yes, yun. Kailangan may date. So, hindi naman sila agad-agad nagde-demolish po, ng mga squatter areas ng walang, tawag dito? Walang pasubali, na walang sabi-sabi. Nakita niyo ba yung sa Muntinlupa ngayon? Yung nagtayo sila ng biglang pader doon sa mismong way.
Yes po, ma'am.
Okay, bawal yun. Bakit? Mali yung ginawa ng Bucor doon. Bakit po? Kasi yung ginawa ng Bucor doon or yung sa mismong Muntinlupa doon, sa ano yun sa Bilibid. Okay? Ang nangyari kasi, binigay nila yung paper 1 day lang. So, a day before sila magtayo. Anong nawala doon? Anong right ang nawala nyo doon? As an individual, anong right ang nawala nyo doon?
Information po ba?
Right to information, yes. Hindi man nga alam ng mga alkalde nila eh. 'Di ba? Ang may alam lang biglaan ng barangay. So, hindi sila nag-take ng action. So, mali talaga ang ginawa nila doon. Pero may karapatan yung Muntinlupa na ipasara yon kung titignan nila yung mga legal actions. Kaso, meron silang magkakamali. Kasi hindi naman agad na porket naisip nyo, ngayon, gagawin nyo yan. How about the people? 'Di ba na dumadaan doon? Okay? Kaya natawa nga ako doon nung pinapanood ko yung video, grabe naman yung sa Bucor, 'di ba? Isang araw lang nila binigay. Paano mag-a-adjust? We cannot, di tayo pwedeng magbigay ng solution na gano'n nang hindi natin binibigyan din yung solution ng magiging problema or subsequent problem doon sa gagawin mong solusyon. 'Di ba? Inaalis kasi nila yung problema doon na doon daw kasi dumadaan yung mga hoodlums or yung mga tumatakas, ganyan, or yung mga nagpapasok ng yung mga illegal or yung mga contraband sa loob ng kulungan. So, sige, isosolve mo yung problem na yon by closing that road. How about the subsequent problem? Diba? Or the next problem na kapag sinara mo yon, saan dadaan yung mga tao? So, nawala yung right ng mga tao doon na alamin. Isang araw lang. Paano makakapag-adjust? So, dapat kailangan bigyan mo na sila ng ibang daan bago isara yun. Sa mga squatter area naman, wala talaga silang laban. Kasi nga, squatter lang sila. Okay? Pero, kung kanwari, nakita ng government, meron naman tayong sufficient funds, bibigyan sila ng relocations or sometimes, yung sa NHA natin, sa mga national housing. Okay? Pero kung kanwari, ang decision ng government not to give them any tawag dito, any relocation, wala tayong magagawa dun. Okay? Lalo na yung, may mga instances kasi wherein alam yung mga ganyan, yung mga ganyang tao, or yung mga ganyang squatter, binibigyan naman talaga sila ng relocation or lupa. Ang problema sa kanila, binibenta nila yung lupa. Tapos hindi sila titira doon. Maghahanap naman sila ng another squatter area. Ang nagiging dahilan naman daw nila kasi, kaya ayaw nilang tumira doon sa mga ganung places, it is because wala daw silang hanap buhay. Yun daw ang sinasabi nila. Okay. May tanong pa ba? Yes.
Thank you po, ma'am. Thank you po.
Okay. Next, Section 10. No law. Okay? No law. Walang batas. Impairing the obligation of contract shall be passed. So, walang batas na walang pwedeng gawing batas na pwedeng i-violate nila yung mga kontrata ng mga private entities. So, non-impairment clause is to safeguard the integrity of contracts, ayan, against unwarranted interference by the state. So, as a rule, contracts should not be tampered by subsequent laws that would change or modify the rights and obligation of the parties. So, there is impairment if a subsequent law changes the terms of contract between the parties. So, imposes a new condition, dispenses with those agreed upon, or withdraws remedies for the enforcement of the rights of the parties. It is anything that diminishes the efficacy of the contract. So, walang ganun na kapag kanwari may contract kayo ng private entities, so tas nagkaroon ng batas na lahat ng kontrata ng gato papalitan. Wala pong ganun. Okay, bawal silang gumawa ng ganung batas. Unless kasi may mga kontrata naman na tawag dito, lumalabag na karapatang pangtao. Doon pa lang papasok yung batas natin kasi pwede nilang ipasok sa under ng Bill of Rights yung ginawa mong kontrata is mali dahil naralabag yung karapatan niyang pangtao. Yun, pwedeng pumasok yung gobyerno. Pero for example, papasok lang yung gobyerno just to have an income or just to tawag dito, to get parang a beneficial or beneficiary from that contract, bawal po. Lalo na kung private entities lang. Papasok lang yan kapag merong violated rights. Yan, diba? Congress cannot enact laws that would alter yan, modify, or amend the rights and obligations of the parties on contracts that have been validly entered into. So, another naman, ito, Section 11, the free access to the courts and quasi-judicial bodies and adequate legal assistance or right to free access to courts and quasi-judicial bodies. So, lahat tayo merong karapatang, magsampa ng kaso. Kahit mahirap ka. Okay? Ano naman yung tinatawag nating quasi-judicial bodies? Quasi-judicial bodies, these are the another agencies or departments here in the Philippines that give a public service. For example, NBI, PAO, the Bureau of Immigrations, FDA, lahat yan, tinatawag natin quasi-judicial bodies. For example, meron kang i-raise sa NBI. So, free din yon. Kailangan meron kang free access doon. Pero kasi, kaya lang sinasabi na magastos kapag magsasampa ka ng kaso. Kasi, una, pamasahe mo, 'di ba? Yung gagalagalin mong mga papers doon, may bayad kasi. Yun doon tayo nahihirapan. Okay? Or doon nila sinasabi na magastos kapag magsasampa ka pa ng kaso. So, quasi-judicial bodies are those entities which are not courts, hindi nga korte itong mga to, but granted the authority by law to hear and adjudicate cases under its expertise. Katulad nga nung sinasabi ko na katulad ng NBI, DIPAW, or sometimes the pleb. Yan, may karapatan ka dyan. This right is afforded only to those indigent citizens as certified by the barangay or concerned DSWD office. Next. Konti na lang. Section 12. Ito. Madali lang naman to. Ano ang law ang Section 12 natin? Ano ang law na sinusundan natin dyan? Gumawa tayo ng another separate law for this Section 12 eh. Ano yan? Any person... yes, ano
Yung
yan?
ano po, RA 7438 po, ma'am.
Yes, very good. Your RA 7438 or yung sa may Miranda rights, di ba? Any person under investigation for the commission of an offense shall have the right to be informed, right to remain silent, and to have your competent and independent counsel, preferably of his own choice. So, yan yon. Ito yung RA 7438 na pinamemorize ko rin, alam ko sa inyo dati. Tama? Yung mismong, yung karapatan mong pangtao. So, no torture, force, or violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. So, bawal yan. Ano nga yung anti-torture law? Ha? Ano yung anti-torture law? That is RA 9745. Kailan ba ginagamit yung torture? Kailan ba sila nagto-torture? 'Di ba nagto-torture sila kapag gusto nilang kumuha ng confession or pag-amin. Ito yung mga napapanood nyo dun sa mga TV na iniilawan, ginagapatay sindi, binubugbog para magsalita. Bawal po 'yon. Okay? Any confession or admission obtained in violation of this section 12 hereof shall be inadmissible in evidence against him. Section 12 yan na. So, the law shall provide for penal and civil sanctions for a violation of this section as well as compensation to rehabilitation of victims of torture or similar practices and their families. So, detailed discussion of these topics will be on finals. Yung rights or Miranda warning nga natin. Maliwanag na tayo dito. Hindi ko na kailangan further elaborate yung Section 12 kasi napag-aralan naman natin na yung RA 7438 with your CLAW212 which is pinamemorize ko pa sa inyo, alam ko. Next, we also have the Section 13. Ito naman, your right to bail. Do you know what is bail?
Piyansa, ma'am.
Piyansa. Or, pag ba nagpiyansa ka, ibig sabihin wala ka ng sala?
Meron pa rin po.
Okay, ang iba kasi, liliwanagin ko lang ha, just to clarify. Hindi ibig sabihin nagpiyansa ka, wala ka ng kasalanan. Yung iba kasi akala nila kapag nagbayad sila ng bail or nagbayad sila ng piyansa, wala na silang kasalanan. Ang piyansa, ito lang yung hindi ka madedetain. 'Di ba? Iba naman kasi yung detain sa kulong. Ang detain, naka-close, nasa detention facility ka or nasa mga jails ka ng mga ng mga police para for the purpose of investigation. Pero hindi ibig sabihin nun is nakakulong ka na talaga, official prisoner ka na or official ka na talaga convicted. Okay? Ang mga bail, eto pumapasok yan for example, nagkaroon ka ng kinuha ka or bigla ka na lang warrantless arrest, ganyan, kinuha ka. Pwede ka magpiyansa. Okay? So, all persons except those charged with offenses punishable by reclusion perpetua. Okay? Any person, basta kahit meron siyang kasalanan, pwera lang kapag ang kaso ay reclusion perpetua or yung merong cases na 20 years to 40 years. Ayan. And when evidence of guilt is strong, shall before conviction be bailable by sufficient sureties. So, hindi kasi naman lahat ng kaso bailable. There are cases na non-bailable. The right to bail shall not be impaired when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required or bawal yung sobra-sobrang bail. Bail is the security given or pansamantalang laya lang. Okay? Pansamantalang laya. Don't you worry, sa criminal procedures nyo, pag-aaralan nyo din yung right to bail or yung the bail processing. Tapos, what are the different types of bail? We have 4 different types of bail na hindi ko naman i-discuss ngayon kasi masyadong mahaba. So, the security given for the release of person in custody of the law furnished by him for a bondsman to guarantee his appearance before any court as required. Kasi yung mga bill natin, pwedeng yung parang nagsasanla ka ng ito yung property nyo, pwedeng in cash din, pwede rin po yung tao mismo. Yung meron lang silang pagkakatiwalaan na, sige, magpapansamantalang laya ka, tapos ang liable yung barangay captain nyo kapag tumakas ka. Ganon. So, we have, okay, ganito ha, hindi lahat-lahat karapatan mo ang bail. Sabi ko nga, there are cases or there are certain crimes na non-bailable. So, kapag ang kaso sa'yo is reclusion perpetua or death penalty, automatically, hindi mo yan right. Kailan lang nagiging right? Kapag ang kaso mo nasa MTC lang, ano nga yung mga klase ng kaso na covered lang ng MTC? Ha? Ano nga yung mga kaso na covered ng MTC? If you could remember, sa ating CLAW212 or Municipal Trial Court, kailan lang pumapasok dyan? Kapag ang kaso ay ilang years? Or ano yung mga cases na hini-hear na
6 years pababa po.
yan. Kapag ang kaso is 6 years pababa, MTC lang natin pinapasa yan, di ba? Kaya sabi ko sa inyo, dapat tong CLAW112 nyo, nakikinig kayo eh. Kasi uulit-ulitin nyo yan hanggang sa, 4th year kayo. Sabi ko, di ba, ang CLAW112 nyo, pinagsama-samang 5 subject yan, na ulit-ulitin nyo hanggang sa pagtandaan nyo or habang sa pag-graduate nyo. So, kapag sa MTC, di ba, ang hini-hear and try natin dito are those cases with a punishment of 6 years and below. So, therefore, you have the matter of right. So, a bail is a matter of right when your case is under MTC. Before or after conviction man, regardless of the offense, you have the right to bail. Kailan siya nagiging, parang discretion? Nagiging discretion yan kapag ang kaso mo napasok sa RTC. It is a matter of right before conviction. Ayan. Except for offenses punishable by death, reclusion perpetua, or life sentence, and the evidence of guilt is strong, in which case, the right to bail, it is not a matter of right, but it is a matter of discretionary, or titingnan muna nila if pwede kang mag-bail or hindi. So, after conviction, bail is a matter of discretion regardless of the offense. So, the application for bail may be filed and acted upon by the trial court as long as the original record of the case has not been transmitted to the appellate court. So, however, if the decision of the trial court changed the nature of the offense from non-bailable to bailable, the application should be addressed and resolved by the appellate court. So, meron din naman kasing mga batas, for example, yung unang batas non-bailable siya, tas biglang naging bailable. Ayan. Pwede kang mag-appeal nun. Diba? Ipapasa mo yung kaso mo sa Court of Appeals, tapos mag-a-appeal ka na for bailable cases. Nagigets po ba niyo sa right to bail? Hindi ako pwedeng mag-focus sa right to bail nyo dahil i-discuss nyo yun sa criminal procedures nyo. Then we also have the section 14. Dito naman, no person shall be held to answer for criminal offense without due process of law. Ulit-ulit na lang to. What is due process? This is the right to be heard and defend before competent court or body. Ibig sabihin nito, bawal kang tawag dito, ikulong agad-agad, 'di ba, nang wala man lang due process of law. So we have the dual suspect of due process of law, the substantive and procedural due process. If you could remember again, as we discussed in criminal CLAW112, the criminal law has 2 divisions. 'Di ba? What are the two divisions laws of criminal law? What are the two divisions? The substantive law and,
Sa-
di ba, procedural law. Yes, Vladimir?
Ma'am, yun po. Sorry.
Diba? Di ba, meron tayong substantive law and procedural law. Ano yung substantive law? Ito yung law na, alin? Ano yung substantive law natin under criminal law? Ayan. Yan ang problema pag hindi nakikinig ng maayos. Ang substantive law, ito ha, makinig kayo sa akin. Explain ko ng mabuti sa inyo para kapag nag-third year kayo, hindi rin kayo mahihirapan. Sa substantive law, ito yung mga batas na nagsasabi or it defines the elements on how a crime can be committed. For example, murder. Paano mo makukumit yung murder? Ito yung elements niya. Yun ang substantive law natin. Pero kapag ang pinag-uusapan naman natin, for example, i-enforce the police officer, nag-commit ka ng murder. Yung mga actions ng police, paano mo naman sabi na tama yung pinapatupad niyang batas? Anong law yun? Ito yung procedural law. Okay? Concerns about the legal process that the accused will undergo before condemnation. Sa substantive law, ito yung batas na nilabag mo or nagbibigay ng mga elements kung paano mo malalabag ang isang batas. Ito yung mga murder, parricide, homicide, ito yung pag-robbery, yung mga RAs, ito yung mga substantive due process. Yung procedural due process is tama ba yung pagkaproseso sa'yo? Ikaw na accused, ikaw na suspect, ikaw na respondent. Dito papasok yon. For example, binasahan ka ba ng Miranda rights? 'Di ba? Sinabi ba sa'yo ng karapatan mong ganito? Meron ka bang right to bail? Ayan. Or after mong mag-hearing ng ganito, tinaan ka muna sa gantong proseso bago ka bigyan ng sentensya. Ayan. So, papasok doon yung procedural due process. Kasi dalawang tinitingnan natin. The moment na gumawa ka ng crime at saka yung gagawin sa'yo as a punishment. Okay? Both substantive and procedural due process must be observed. Kailangan tinitingnan nyo yan. Otherwise, the deprivation of accused rights is invalid and illegal. Nagigets po ba itong natin? Section 14. Your right for due process of law. That is the main title of this section 14. Right to the due process of law. Nagigets po ba? Hello?
Yes po.
For example, sasampahan natin ng kaso yung pulis kasi mali yung pagka-aresto niya. Ano yon? Substantive o procedural?
Procedural po.
Procedural. For example, sasampahan ka ng kaso kasi nagnakaw ka. Substantive, procedural.
Substantive.
Substantive po.
Nagigets yun na yan. Lahat yan, division po ng ating criminal law. Okay?
Law.
Next, section 15. Ito naman. The privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion when the public safety requires it. Ano po ba yung habeas corpus, ma'am? Habeas corpus is a legal action or writ by means of which detainees can seek relief from unlawful imprisonment. Ito yung your body should be set free or meron kang karapatang lumaya lalo na kapag unlawful imprisonment. That is your habeas corpus. So, in case of invasion or rebellion, alam nyo ba yung mga rebellion? Ito yung public uprising. Ito yung using force and violence to take over the government. Ayan. When the public safety requires it, the president may suspend the privilege of the writ of habeas corpus. Ito yung bigla na lang silang nagpapahuli or hinuhuli nila kung bawat sinong makita nila. Ayan. Writ of habeas corpus for a period not existing 60 days or place or the Philippines or any part of the country under martial law. Ayan. Kapag naka-martial law kasi, nawawala yung habeas corpus natin. Naaalala nyo ba yung sa Visayas ba noon or Mindanao? If I'm not mistaken, bigla silang nagkaroon ng martial law. So, ang nawawala kasi noon yung habeas corpus nila. Ano po ba yung habeas corpus? Ito yung, di ba, kapag Naalala nyo yung reglementary period under Article 125 na kapag hinuli ka under warrantless arrest, meron silang 12 hours, 18 hours, and 36 hours para patunayan na valid ang pagkahuli nila sa'yo. Naalala nyo yon?
Yes po, ma'am.
Ayun. So, yun ang nawawala sa habeas corpus during martial law. So, pwede silang manghuli kahit sinong gusto nila, nakita nilang lumalabag ang batas. So, hindi sila pwedeng mag-questions ng, within 12 hours, kailangan pakawalan nyo na po ako kasi hindi nyo naman napatunayan na itong minor offense ko eh. Ayan. So, within 48 hours from the time of the President suspended the writ, he is required to submit a report in person or in writing to Congress. Congress will then have to vote jointly or by at least majority of its members in its regular or special session to affirm or revoke such suspension. So, the President cannot set aside the decision of the Congress. Kailangan kapag within 48 hours, nagdeklara siya ng martial law, automatically kung meron mang nahuli, is gagawa siya ng written letter or report just to have a voting about that one. Nagigets na yan tong habeas corpus. Ito yung karapatan nyong lumaya or questionin bakit ka tawag dito na-detain or bakit ka kinulong. Kapag nagkaroon kayo ng warrantless arrest, okay, lagi yung tandaan po yung 12-18-36, 12 hours for minor offense, 18 hours for, anong tawag dito? For, and it's not afflictive eh. Ang afflictive kasi afflictive punishment, and then we also have the 36 hours for the capital punishment. So, tignan nyo yung mga yan. Then, Section 16, the speedy trial. Ito na maraming lumalabag dito. So, lahat kasi, all persons shall have the right to a speedy disposition of their cases before all judicial or quasi-judicial or administrative bodies. Speedy trial is a trial conducted according to prevailing rules and procedures that takes place without unreasonable or undue delay or within statutory period. Kaya meron po tayong right to speedy trial or mabilis lang dapat yung trial ng kaso. Kaso, tingnan nyo, hindi nga nagagawa yan. The period of trial following the general rule is just only 180 days. Pero di ba may mga kaso nag-extend ng 20 years, 10 years, ayan. So, the period of trial following general rule is 180 days unless extended by proper motion. So, extend tayo ng extend kasi kulang ng evidence, kulang ng ganito, kaya na-extend, nawawala yung 180 days na yan. A motion to dismiss may be filed based on the ground of denial speedy disposition of the case. Ito, Section 17. Right against self-incrimination. Ito. So, no person shall be compelled to be witness against himself. Or kapag kanwari nakita mo yung questions is parang hitting below the belt, pwede kang magsabi na you're right against self-incrimination. Or kasi baka yung sasabihin mo, pwedeng ikaw or magkakaroon ka ng kasalanan. So, the right against self-incrimination covers testimonial compulsion only on the compulsion to produce real or physical evidence using the body of the witness or accused. It applies to commutative testimony and not mechanical testimony. Examples of compelled self-incrimination includes instances where the police or other officials use threats or force, violence, and intimidation to obtain confession. Ayan, bawal yan. Threaten harm to a family member or loved one in order to obtain a confession or evidence. Bawal nga po yun. We also have Section 18. So, no person shall be detained solely by reason of his political beliefs and inspiration. So, ibig sabihin na anti-Duterte ka, kailangan kulong ka nila. Walang ganon. So, bawal po yun. No involuntary servitude. What is involuntary servitude? Ito yung sa pilitang pagtatrabaho or pagbibigay ng service. In any form shall exist except as a punishment for a crime whereof the party shall have been duly convicted. May mga ganyan po na may mga cases. I forgot what law is that. Pero alam ko yata yung mga pumupunta sa mga beer house ba yun? Ayun. Ill repute. Yung mga nag-acquire ng mga services yata ng mga, if I'm not mistaken dun sa nabasa kong law. Yung mga pumupunta sa mga houses of ill repute or even yung mga kumukuha ng service ng prostitute, binibigyan sila ng 50 days na service, community service. Okay? I'm not sure for that. So political belief is a certain set of ethical ideas, principles, doctrines, myths or symbols of a social movement, institution, class, or large group that explains how society should work and offers some political and cultural blueprint for a certain social order. So, iba-iba naman yung sa political belief natin, di ba? Merong mga anti-Duterte, merong pro-Duterte, o merong dilawan. So, regardless of what is your belief in political issues, wala silang paki doon. Hindi ka pwedeng ikulong dahil taga-dilawan ka. Hindi ka pwedeng ikulong dahil taga-Duterte ka. Walang ganon. Another one is yung involuntary servitude. Ito na nga. Refers to a condition of enforced and compulsory service. Ito yung, bayaran mo yung utang mo, magtrabaho ka sa akin. Ganyan. Bawal kasi talaga yan. Unless pinag-usapan or punishment siya. So, refers to condition of enforced and compulsory service induced by means of any scheme, plan, or pattern. Sa kadalasan ng involuntary servitude, pumapasok yan sa trafficking of the person. Kasama yan. Yung alam mo yung pinagbayad ka ng ganito, tapos pagtatrabahuhin ka lang na as ayaya or parang alila dito sa ibang bansa. Yan, bawal po yan. Unless merong batas na nagsasabi na, kapag munta ka sa ganito, ganito ang mangyayari sa'yo, community service ka. Meron pong ganun. Then, Section 90 naman, excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Ayan. So, bawal yung excessive fines. Yung pagbayarin natin sila ng gantong 100 million. Ayan. Bawal yan. Cruel or degrading, inhuman punishment. Ito yung silya electrica, kaya nga inilis nila yung mga yan. Kasi bawal na yan. Pumapasok na yung human rights. Neither shall the death penalty be imposed unless for compelling reason involving heinous crimes. So, yung death penalty natin, dati, legal yan kasi nga may batas. Kasi, yung mga binibigyan naman ng death penalty is yung mga tinatawag nating heinous crimes. Ano po ba heinous crimes man? It means ito yung mga type of crimes wherein ang tawag ito, yung crime nila or in nature are very serious. For example, murder. Ayan. Pwede nating sabihin na heinous crime yan. So, heinous means extremely evil or horrible. For example, nag-rape siya ng bata na 3 years old pa lang. Ayan. We can consider that as an heinous crimes. So, the employment of physical, psychological, or degrading punishment against any prisoner or detainee or the use of substandard or inadequate penal facilities under subhuman condition be dealt with by the law. So, bawal kasi yun yung mga pagto-torture, bawal na yan dahil sa ating human rights. Eto, no person shall be imprisoned for debt or non-payment of poll tax. Yung poll tax, yung araw-araw na tax na binabayaran natin. Walang ganun. So, no person shall be twice put in jeopardy of punishment for the same offenses if an act punished by a law in accordance, conviction, or acquittal under either shall constitute a bar to another prosecution for the same act. Yung Section 21, bawal tayong or no person shall be put in double jeopardy. Alam niyo ba yung jeopardy? Eto. Double jeopardy means that when a person is charged with an offense and the case is terminated already by acquittal or conviction or in any manner without the consent of the accused, the latter cannot again be charged the same or identical offense. For example, ito, si Jose, sinampahan niya si Wally ng kaso na robbery. Ngayon, habang nagkaroon ng hearing, nagkaroon tayo ng proper hearing, nagkaroon ng due process of law, ang nangyari, na-resolve or parang acquitted itong si Wally. Tatanungin ko kayo, pwede bang magsampa ulit ng kaso si Jose? Kay Wally?
Hindi po, ma'am, under dun sa same na offense na pinapataw po sa kanya, ma'am.
So, for example, ang sasampa ulit sa kanya ni Jose is robbery. Same information. Same, tawag dito, same scenario, same investigation. Bawal na yon. Kasi anong tatawag doon? Double jeopardy na yon. O for example, ang kanwari, nakulong naman si Wally kaso ang penalty niya is 3 years lang. Ayan. So, after niyang lumaya, sasampahan mo ulit ng kaso, pwede ba yon?
Hindi na po.
Hindi
Hindi
na.
po.
Kasi ang tawag natin doon, double jeopardy. Kapag na-hear and try na yung case tapos nag-come up na siya with the decision of the court, whether acquittal or convicted man, therefore, hindi mo na pwedeng ulitin yan. Siguro pwede mo siyang sampahan ng kaso, kailangan iba. Or ibang circumstances naman, ibang evidences naman, sa ibang scenario naman. But within the same case and scenarios, bawal po. Okay? What if, ma'am, inulit niya? Same offense. For example, robbery din, ma'am, kaso iba na naman yung ninakaw niya ngayon. Ayun, pwede yun. Pero for example, yung paring dati yung issue, bawal po yun. So sabi nga niya, this is a criminal procedural defense that prevents a criminal defendant from being tried for the same criminal act twice. Okay? That is double jeopardy. Ito, Section 22, no ex post facto law or bill of attainder shall be enacted. What is ex post facto law? If you could remember.
Ma'am, yun po yung like, halimbawa may offense, may isa pong act na kinumit. Noong time na po yun, hindi pa po siya crime, ma'am. Then, halimbawa yung isang mayor, ganun nga po, doon pala magiging, mag-e-enact ng law after yung of certain offense na yun is, act na yun is nagawa po, ma'am.
Very good. Natatandaan niya pa. Ito yung mga batas na, ano nga yung kinukwento ko sa inyo noon, di ba? Kay langgam, yung mamamatay langgam. Tama ba ako?
Yes po, ma'am.
Diba? If
Yes
you
po,
could
ma'am.
remember, ito yung sinasabi ko na mamamatay langgam, tapos bigla niyang nagkaroon ng batas na mamamatay langgam, bigla niyang sasampahan ng kaso. Ang ex post facto law, a law that makes illegal an act that was legal when committed and increases the penalties for an infraction after it has been committed. So, bawal kang magbigay ng, for example, ng conviction sa isang kaso or sa isang tao na ginawa niya yung isang bagay kung wala pa naman yung batas na yon. Kung ginawa niya yung legal pa rin, therefore, legal siya. Yes, Jonel Pamintuan.
Ma'am, yung parang po bang sa ano po yun, yung I love virus? Yun po ba?
Oo, tama. Yung kay Onel de Guzman. So, dahil wala namang batas na nagsasabing, tawag dito, bawal or parang mali yung ginagawa niya, therefore, legal yon. Okay? That is an ex post facto law. Then, next one is Bill of Attainder. What is Bill of Attainder? It is a legislative act that declares someone guilty of a crime and assesses a punishment without providing a trial to prove the crime. What is Bill of Attainder? Ito yung bawal kang gumawa ng batas or nagsasabi na kahit wala kang, tawag dito, kahit wala ng trial, agad-agad kulong ka na. Kaya ano ang nababiolate nun? Ano ang nababiolate nun? Agad-agad guilty of crime ka na, wala pa mang hear and try. Wala pa mang trial na naganap sa korte. Ano yon? That is?
Right of due process po.
Your right to due of process is nawawala. So, bawal kasi yung tinatawag nating Bill of Attainder o yung law na nagsasabi na agad-agad criminal ka kasi ginawa mo yung gantong bagay. Sabi nga niya, a legislative act that declares someone guilty of a crime and assesses a punishment without providing a trial to prove the crime. So, that is Bill of Attainder. Wala pong pwedeng or bawal gumawa ng batas na ganun ang ating mga legislator. So, that ends my discussions about the remaining topics of Section 3 to Section 22 of the Article 3 or Bill of Rights of the 1987 Philippine Constitution. Do you have any questions? May tanong ba kayo?
Ma'am, yung pinapamemorize nyo pong
Wait lang.
yan po, yan din